All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. We're here today in the matter of David Collier versus Jennifer Johnson, our case number 1CA-CV22-0551. This is the time set for oral argument. As you probably are both aware, you're each afforded 20 minutes, and it's up to you to keep track of time you may wish to reserve for rebuttal. We have conferenced the case this morning. We've reviewed the record and your briefs, so keep that in mind during argument. This matter will be live streamed on YouTube and recorded and available for later review if you feel so inclined. But because of that, please, when you stand up and begin your argument, identify yourself and identify who you represent so parties can, or viewers can keep track of who's who. I think that's everything I need to say, so we'll begin with appellant.
May it please the court. Good morning, Your Honors. My name is Dorian Eden, and I represent the appellant David Collier. I believe we can talk about two main issues in this case. And a lot of it ties in to these two issues. The first is depreciation and whether that should be attributed to income for child support purposes. And the second is the characterization of separate property and characterization of community property. I want to start with the depreciation. The United States Supreme Court has said as far back as the 1920s that depreciation is income. The Arizona court has not gone quite so far, but in 1995, the court determined that it was error if the trial court did not consider depreciation and whether it should or should not be included as income. We believe that the trial court erred when it failed to include Ms. Johnson's depreciation as income. It did not reduce her actual dollar income coming in. Rather, what it represented to Ms. Johnson was additional cash that would be available to her by taking deductions and therefore having tax savings.
How do you know that the court didn't consider depreciation?
There was no there was nothing in the minute entry, in the divorce decree that spoke about depreciation.
Did you request findings of fact and conclusions of law?
They were not requested, no.
So don't we infer then that the decree considered everything it had, or the trial court considered everything it had to and made the findings that are appropriate?
So if there is, yes, however, under the Elliott v. Elliott case, the court also has to, or the conclusions that are reached by the trial court also have to there has to be support for the conclusions that the trial court reached. So if under the Baker case, it's saying that you have to, if depreciation is raised as an issue, you have to at least consider a trial court judge. We don't know if the judge considered it or not in this case because it's not addressed.
But we presume it did.
Except I think the Elliott case.
Wait, let me tee it up more directly. I agree with you. Mm-hmm. They need to consider depreciation, but we have, say, a situation in which the decree is silent as to depreciation, at least explicitly silent. But we presume, as I understand the law, that the trial court knows the law and followed the law. So do you agree with all those kind of principles that I've said so far?
Yes.
Okay. So why don't I now read the decree and say, I assume the trial court considered the arguments regarding depreciation, accepted them to the extent they were correct, and disregarded them to the extent that they're incorrect, and scour the record now to find that there's some evidence, whether there's some evidence to support that decision.
So I understand what you're saying.
Good, because sometimes I don't make sense, so feel free to tell me when I'm not.
But I think it's a leap to say we're going to assume that the court considered it and disregarded it to include as income, as opposed to there being something explicit in the decree saying the trial court considered the argument regarding depreciation and either agrees that it should be included as income or disagrees that it should not be
But you
included
guys
as income.
presented competing arguments on that issue, correct? So
Correct.
it wasn't as if we look at a record and say there isn't anything about depreciation, or there was only one side presented, how could the court have found the other way? When you had competing evidence and the court makes credibility determinations, and as Judge Moore says, we presume knows the law. So where in this could we go your way without reweighing evidence that the trial court clearly heard and made determinations about?
Well, I think that it needs to, I go back to, I think it needs to be explicit, whether it was considered or not considered. And this is important.
If you request findings of fact and conclusions of law on that point, yes, but otherwise at least all the case law I'm aware of says, we presume they knew and followed the law, and we infer that they made every necessary finding to reach the result that they got to.
What I'm struggling with is how do we know if the trial court reached the necessary result if it's not addressed? That's the concern that I have.
Okay.
There were other issues on child support that Ms. Johnson recognized as well. Those, I think, can be addressed with the remand, if the court were to remand to order the trial court to address the depreciation. The second area, then, is the characterization of separate property and community property. And in that area, I see there's 4 issues. There's the issue about a $14,000 check that came from Mr. Collier's mother's account. There's retention bonus. There is his Chase account that ended 3713, and then there's the tracing and commingling with regard to the Navy Federal accounts. With regard to the $14,000 check, ARS 25213A is pretty clear that if a gift is provided to one spouse during marriage, it is presumed to be separate property. Mm-hmm. In this case, the check was given to, or was drawn from the mother's account, the paternal grandmother's account, and given to appellant less than a month before he filed for dissolution of marriage. It was only made payable to him, his siblings.
I understand this is the character of the evidence, the nature and extent of the evidence that was provided, and the briefing was very thorough on that. But again, my understanding is that there wasn't a request for findings of fact and conclusions of law. Not to this issue either, correct?
There were no findings of fact and conclusions of law requested at all at the trial court level. Okay.
So notwithstanding the character of all the evidence that you're talking about here relating to us, aren't we required to presume the court looked at all of that and said, notwithstanding all of your evidence, I find that it's not a gift?
I think that the trial court, again, needs to explain if the presumption should be, under both the statute and lots of case law, that separate property that is deposited into a joint account, let's assume, because it was deposited into his Navy Federal account. And I'm not acknowledging that Navy Federal is necessarily joint, but taking that argument, and let's say it is found to be a joint account, as the trial court found. If he is depositing a gift, so separate property into a joint account, Stevenson v. Stevenson says there's no presumption that that's a gift to the community. Noble v. Noble, and we've got a long line of cases that say there's no presumption of that being a gift to the community. So if there was some finding that it was not a gift to the community, or it was a gift to the community, again, the decree is silent on that. So we don't know if the judge considered or what he was weighing when he determined that the entirety of that Navy Federal account, which included the $14,000 gift a few weeks before the filing for dissolution, was whether it was in fact.
And I'm glad that you went there, because I misspoke. The finding isn't that it wasn't a gift. The finding was that it was commingled. So, which is what you're pointing out. But we come back to the same question, which is, it's not unlimited the circumstance that, the law is clear. You don't automatically take separate property and it becomes, community property when you put it in a joint account, but there are some conditions associated with that, aren't there?
Yes.
So, and those conditions are that it's traceable, that it remains identifiable in its character as separate property. Okay, so the court goes through an analysis of the evidence that was presented and says these properties are hopelessly commingled. So what are we to do with that? How do I get from there to where you're standing without reweighing evidence?
When the court, my reading of the transcripts and reviewing the evidence, when the court was talking about the Navy federal account, 0861, being hopelessly commingled, that was for a period of time, essentially a snapshot in time, because there were community funds deposited into that account for roughly 15 months of the parties' entire marriage. Once community funds stopped being deposited into that account, we then fast forward to a month before the petition for dissolution of marriage is filed, and that's when the $14,000 check is deposited. In my opinion, it's clearly identifiable because at the date of service, there was roughly $20,000 in that account. We know that there was $6,000 already in the account, but then my client deposited the additional $14,000. So I think we need to, a lot of it is a timing issue, because if there's no presumption of a gift to the community, which my client clearly indicated and testified that he believed that he was depositing that check into what he thought was his separate property funds. He was not intending to gift that $14,000 to the community. When the decree is silent on why that then is not separate property, we don't have any way to analyze the court's rationale behind either ignoring 25-213 and Stevenson and Noble in those cases that talk about needing to look at intent.
How do we know which way the court went?
I'm sorry?
How do we know which way the court went? I think there's two ways to look at the ruling below, from my perspective anyway. One is it was commingled and you didn't sustain your burden of tracing necessary to establish that it wasn't commingled. You've got a pretty good argument considering the limited timing there that maybe that's wrong. But the other argument, the other potential finding that the court may have made is that it wasn't a gift, or you didn't meet your burden to show that it was a gift. So how do I reverse when there's two potential arguments that there's support, at least some support from the record for affirming?
If we look at the evidence that was...
And which one is it? Which one do you think is the way the court ruled below?
Well, the court clearly determined the entire account to be community. So, and the judge had expressed concern about the exhibit that was provided. I mean, the check was written from the paternal grandmother's account. My client's siblings both had signed statements acknowledging, saying, yes, this is a gift.
Unnotarized statements, I mean, from the record, right? So they just,
Correct.
okay.
Correct. But there isn't any requirement that they be notarized.
No.
But that was obviously a concern the court had because it specifically addressed that particular character of the statements, correct?
Yes, it did. Yes, it did. But it was my client's sister, brother, and sister-in-law who all signed the statements.
Not the gifter.
Correct, not the gifter. And I have my assumptions as to why that happened, but it's not clear on the record. My client also testified that it was common for his mother to give gifts to the siblings. I do want to move on to his retention bonus, and his Chase account 3713. The retention bonus, let me talk about 3713 real quick. That was, for reasons unknown, the court did not use date of service for dividing that account. It used a date a little more than a month after date of service. There's not all that much money at issue here. However, it was...
Could it be because of the money that was transferred, and maybe I'm conflating the accounts, but the transferred that money away and then put it back, and so that made more sense to wait till he'd put that money back that he apparently acknowledged that needed to go back?
So if the court were to use that date, that was July 23rd, so that was just a couple days after date of service. And that, once the money went transferred back to the joint account, then it was, the 3713 account had a zero balance. And so the funds that then went into 3713 were his post-decree earnings. And then there were some payments to Ms. Johnson out as well. So at this point, again, we go back to 213. This is post-decree earnings. It should have been his sole and separate property. That account should not have been divided. The retention bonus, similarly, because it's earned a day at a time, should not have been considered to be entirely community because of when service occurred. And so if he's not earning that money until, let's say, August, September, October, at that point, service has already been completed. The termination of the community has already occurred. My client should have been able to receive his community, or his separate property portion back out of that account, or
Counsel,
from the retention bonus.
let's say that we agree with you for sake of argument, but it goes into a particular account, and the court's ultimate holding is that this account is community and divides that community, ostensibly because it can't be traced. So even if we agree with you that the court erred in not affording him one particular piece of that particular bonus, if it goes into an account and the entire account is commingled in, and the court has ruled that he didn't properly trace it, what do we do with that? So now it is a drop of water in a sea.
I understand that. That is a difficult one to trace because it clearly went into a joint account and money was coming in, money was going out. I think, though, however, the $125,000 that came out, and I'm going to switch back to the Navy Federal, the $125,000 that came out roughly 8-9 months after the party's marriage, so it came out of what was the account solely in David's name, and then a CD was opened. At the time that money came out, there was not sufficient community funds that had been deposited into his Navy Federal account, and there was, in addition to Dr. Collier's testimony, there were bank statements and summaries provided of all the monies in and monies out, and then he also testified that once his community paychecks stopped being deposited into the Navy Federal account and went into the party's new joint Chase account, those same bills started being paid. The expenses that had been coming out of his Navy Federal account were then coming out of the joint Chase account. So to completely disregard the money in and money out, or at least the dollars that existed at the date of marriage, plus then the dollars that were put in as community expenses, and then the dollars that were subtracted out as community expenses, I don't know how, it just seems that we believe that the $125,000 was very clearly had to have come from separate property funds, or at least some percentage of it was from separate property funds, because at the time that money had been withdrawn, I believe there was only about $65,000 of community funds that had been deposited.
Counsel, I want to ask you, and I know you probably want to reserve some time, so I apologize for this, but do we have jurisdiction to consider your challenge to the attorney's fee award?
Your Honor, I would agree with Ms. Reardon's position. I don't think so. So that would be waived.
Dang it. Let me push back.
Okay.
There's about 12 or 9 memorandum decisions that say we don't. They cite to 2 cases that do not deal with a situation in which the attorney's fee, I'm calling it the entitlement award, is certified under 78B. We are not bound by memorandum decisions.
Correct.
Is there any authority that says that we don't have jurisdiction to the entitlement decision as opposed to the amount decision, the later one that was certified under 78C? But you've already conceded, so I will not force you to continue this argument.
Well, and when I drafted the opening brief, I felt very confident in my position, and then I have felt less confident.
Well, I understand why, because there's a weight of persuasive, though not binding authority that
Right.
seems to indicate that.
Right.
And again, maybe if you want to reserve your time for arguments you want to make, that's fine. So,
I'll reserve any remaining time I have. Thank you.
May it
and
please the
if
court.
I could admonish the smirking away out there in the audience. Just kidding, it's fine.
I apologize for Mr. Brookshire.
No, it was totally appropriate, but it was. I made the mistake of making eye contact with him, and he kind of smirked at me. But it was a perfectly appropriate smirk,
I have made
considering
the
what I
similar
said
mistake
minutes
at
ago.
times.
I'm sorry.
Your Honor, may it please the court. I'm Christy Reardon representing the appellee Jennifer Johnson, formerly Jennifer Collier. I want to start with the tracing issue. It all starts with Porter. And if a reading of Porter shows that unless you can explicitly trace the funds in an account, and explicit is a very high standard, then the entire funds are going to be transmuted at that point.
I'm aware of, there's a lot of case law that suggests that we don't follow the first in, last out type of methodology. If that did apply, would that work here?
Well, first in, first out wouldn't apply because of the sheer volume of how the money was moving around. And part of it, too, Your Honor, is going back to, okay, the argument of what these expenses were for. Throughout the opening brief, and I think the reply, they were referred to as community expenses.
There's nothing in the record that shows they were actually community expenses.
Exactly. And
That's
in fact,
why, so even if we applied a first in, first out, or whatever,
Correct.
first in, last out
Correct.
method, we don't know what those
Yes.
withdrawals were for.
Here's the bigger issue with that first in, last out methodology. It completely undercuts Arizona's community property presumptions. The presumption is that the separate property holder is supposed to meet that burden. The presumption is that if you can't explicitly trace the separate funds, the account is community. So if we were to sit here and say, let's apply a first in, last out methodology, it doesn't work with the scheme that we have going all the way back to Porter. There's a reason. There's also a reason we don't have a family expense.
But don't we
method
also
in
have
there.
presumptions that, if you've got an account and you've got a separate asset, you don't presume to gift it to the community just because you...
And there's absolutely no argument being made here that just the mere fact that community funds were put in that account was a gift of the separate property portion. The Cooper case is tremendously on point. In Cooper, there were funds already in the account on the date of marriage that during the marriage community paychecks, like in this case, went into that community expenses or expenses in general were paid. How can you possibly tell, was that paid from the community portion? Was that paid from the separate portion? In touching on the argument that at the time of the $125,000 being pulled out, there wasn't enough contributions from the paychecks to cover it, what's notably missing from that argument is what happened to those funds after they were put into the account. They were put back into it. And after that point, more deposits from paychecks had been made, more expenses had been paid. And again, these are not mortgage expenses. These are not even utility expenses. We are seeing ATM withdrawals, checks that could be to cash. There's no way to determine what those expenses are. One of the things that Father said in his opening brief was mother's accounts were treated differently. And I can't say that I entirely understand part of the argument, but let's talk about mother's child support account, for example. I term it the child support account, but it was an account that did have both separate and community funds. That account was traceable because at the time of the marriage, there was, and forgive me, I think it was $19,000, I forget exactly in it. The amounts contributed by the community were rather de minimis. So if you take all of the withdrawals from that account during that time and you apply it to the separate property, you can clearly, which is what our argument was, that clearly if you take all of the withdrawals, just apply it to the separate property portion, the community portion.
Isn't that kind of a first in, last out approach, though?
But it's not, Your Honor, because you can still see where the allocation of funds. You can still see because it wasn't so hopelessly commingled. And that's the thing. It's explicit tracing, but you have to be able to identify which funds. If you applied that, mother took the position, apply that directly to the separate property holder, we can determine that, okay, the community portion, we're essentially putting the presumption in favor of the community there, whereas father is trying to say, you need to take all these expenses out of this account and apply it only to the community property portion. And this isn't like it was one large expense and one large deposit. This account was a mess. You could tell from the judge's frustration on the record. You could tell from the findings, which is a factual finding that this court made, that it is hopelessly commingled. It is not within the purview of this court to go back and reweigh the evidence. A lot of this was also credibility. That segues me to the $14,000 from father's mother, which the issue is much less about tracing. A review of the transcript reflects the court was extremely troubled by the evidence that it was receiving. That was a credibility determination that should be made by the trial court. The trial court, the evidence it had was father's testimony.
Well, it's possible to read the record to support your conclusion there, but do we have a finding as to credibility? Do we have a finding as to whether this was a gift or not?
We don't, and Your Honor, we don't have to because no findings of fact or conclusions of law were made. What I can tell you, though, is you can glean a lot from what the court was saying about the notary. And the court wasn't saying this is inadmissible because it wasn't notarized. The court was essentially saying, I don't give this as much weight because it's not notarized. And yes, very notably, the gifter never opined on this. It was other people in unsworn declarations, so to speak. It was up to the trial court to determine the weight of the evidence and the credibility of the witnesses, the credibility of those unsworn declarations. And it didn't have to make a finding.
Court, and maybe this is more of an academic exercise, but find that it wasn't a gift when there really wasn't any evidence to say that it wasn't. I mean, the court could disbelieve the evidence, but you didn't present anything to say, no, this was intended to be a gift to the community.
And it wasn't my burden. It was father's burden to show that there was donative intent delivery and irrevocable vesting of title. Father did not show that. It was father's burden.
He presented some evidence.
He did present some evidence.
Yeah.
The court clearly did not find credible. It did not find that father met his burden of proof of showing that that was indeed a gift. Going to the retention bonus, the issue there is also not one of...
Would you agree, I'm tipping my hand a little bit, it was separate property?
The retention bonus?
Yes.
I would agree that a portion of the retention bonus would have been separate property, correct.
That was that 1/365th.
Yes, Your Honor. Herein lies the issue. We don't even know if that retention bonus still existed as of the date of service. That would be no different from me getting a divorce and saying in the divorce, here's a check from 2 years ago from my mother to me that says gift. I get that money back, but not showing what happened to it after the fact. We don't know because there's a dearth of bank statements from when that bonus would have been paid to the date of service, what happened in about a 4 to 6 month period of time. So for all we know, that retention bonus was taken out the next day and the parties took a trip.
What if he had, well, I think the record suggests that he didn't, but it's kind of silent. I mean, he was not obliged to repay it, at least as far as we know.
Correct. Your Honor, the bigger issue is...
If he had been obliged to repay it, would that change the analysis at all? Would he have a claim against the community then, based upon the way it was?
I don't believe so, Your Honor.
Why not?
Because the asset in question is what existed as the date of service. We don't even know if that retention bonus existed as of the date of service. So whether or not he was obligated to repay it is, so let's say that the day after they got the retention bonus, they bought a car with it and jointly titled it. I would posit to you that that was a gift to the community, and the fact that the retention bonus he may have to pay back, he gifted it. But what the real question here is, what is the asset in dispute as of the date of service? And he didn't even prove that this exists. In terms of Chase account 3713, I don't want to spend that much time on it because I believe the amount in controversy, the swing is about $1,200. I would posit that even if it was an error, it would be rather harmless error because it's still an equitable division of assets. You were spot on in terms of there was money going back and forth. The court used a different date largely because of that. I think it was the reply brief, it said that the answering brief was silent, or not that the answering brief was silent, but that mother's pretrial statement was silent as to that account. It wasn't. In fact, that kind of also explains why the court had to do what it did, because there was so much money moving around. We tried to address that account via kind of a different way, along with, because the money had been going back and forth. But Father did not prove that that paycheck was all sole and separate either. So even with Father's argument, and again, this is a very de minimis account, or a de minimis issue, Father didn't meet his burden there.
I read your briefs as conceding that we need to remand on the child support issue. Is that correct?
Yes, Your Honor. Unfortunately, I think what happened is that there was a worksheet that didn't get cleared. And so there's information in there that has, frankly, nothing to do with this case. It unfortunately, because of when the notice of appeal got filed and then the stay, it wasn't something that could be fixed later on as well. That would have been certainly more cost-effective to everyone. But the issues in the child support worksheet, that is, yes, please, our position is to vacate the child support order, remand for the order to be consistent with the evidence. In terms of...
Are there any special instructions that we should or shouldn't give to the Superior Court when we're remanding? I mean, I've seen lately that we say remand for just those to correct, but do they get a hearing? Are there other issues? What should we be more direct to the Superior Court about what we want them to do, what they can't do?
Thank you, Your Honor. I don't see this as being an issue where there's not sufficient evidence in the record. The evidence was there. There were clerical mistakes essentially in that worksheet. Vacating the worksheet, vacating the child support order with instruction to, I do believe the court could.
So your argument is that we should vacate and remand to reconsider based upon the existing record?
Based upon the existing record, in terms of those errors in the worksheet, the depreciation expense is a different issue. I'm talking about the credits in the worksheet to remand for consistent with the evidence.
Let me play devil's advocate. Since the record, or since the order is kind of silent, though I think we have to find certain implications out of it, but since the record is silent as to how it considered depreciation, why wouldn't we just vacate and remand on the existing record? And if the court wants to consider those arguments differently now, it can on depreciation, and maybe they can ask for findings of fact so they can better appeal in the future.
And Your Honor, one of the reasons I would say that I don't think that would be necessary is I do think it is pretty clear from the record that the court intentionally did not include the depreciation. The suggestion that the court didn't consider it is entirely belied by the transcript. In fact, perhaps the biggest conversation piece beyond the tracing issues between Father's counsel and the court at that hearing was the depreciation. It was extensive. The court clearly made the decision that the depreciation shouldn't go in there. In terms of, if the court would like to hear from me on that issue, I disagree that depreciation should always be added back in. In fact, we have a case, Baker v. Baker, that allowed depreciation to be treated this way. It did give us essentially factors that the court's supposed to look at, what's being depreciated, the importance of the depreciation, but there are certainly times that depreciation will reflect an underlying expense that impacts cash flow. So I do believe that the court dealt with that depreciation issue, that the only child support issues we have are the credits in the worksheet, and that this court could remand to specifically address the credits. Frankly, this court could also remand with instructions on what figures to put into those credits based on what the evidence was presented, but we're specifically talking about the credits, the child care, the health care, the children, the extra children deduction.
And are you saying those things were either not disputed at trial or stipulated to, and therefore it's just a straight ministerial error, and that they put in a number?
Exactly, yes, Your Honor. So if you look at Father's pretrial statement, he conceded that there was one other child.
Right.
So that is undisputed. To my recollection, the only disputed portion of the child support worksheet left was mother's income, which again, the court addressed with the depreciation, but also the child care expense. I think mother's position, and I apologize if I'm off, was $800, and I think father's was $400, that mother had that expense, not both of them.
Right.
So it's either $400 or $800. That is something that hopefully on remand would not necessitate a new hearing. That is one concrete issue. Both parties presented evidence. The court just needs to determine that.
I just don't want to create more litigation below over questioning what we meant when we think we're being clear, but
Yes.
obviously with going over it later, things can be found that are unclear.
Yes.
So.
And Your Honor, I suppose the clearest directive to the trial court would be to remand for the court to fix the credits in the worksheet consistent with the evidence presented.
Okay, thank you.
So I assume you don't think there was jurisdiction for us to consider the
Correct, Your Honor.
attorney's fees award.
I do agree with you that there are many memorandum decisions on it. In terms of published opinions, there is one. However, it predates some rule changes.
What's
and,
that published opinion?
and other things. It was,
I assume it's Gandini, the one you cite in your brief.
it is one that I don't think I'm going to pronounce as effectively as I would like to. Yes, Gandini v. Soraya.
Right, Gandini did not involve a 78B or
Yes,
equivalent
Your Honor.
certification, so.
The issue here is that though once it was signed in January, that is when the judgment itself that they are appealing from. A finding is not, that was just a
But it
finding.
was certified. The court certified and said this entire decree is now immediately appealable. Go forth and prosper. So
Correct, but there's also a reason we have a difference between B and C, and that it was still outstanding. The issue of attorney's fees was still outstanding.
The amount.
That what was the judgment, the actual judgment, and that's what the father needed to appeal from, was the actual judgment on attorney's fees. Appealing just the finding of attorney's fees is what, all he did was appeal a finding that attorney's fees are appropriate. We now have a
and that's all he
judgment.
argues in the brief. He doesn't argue in his briefs that the amount was wrong. He just says the court erred in finding that the fees were appropriate.
Correct, Your Honor. And even if this court
So
then,
why can we take that up?
because
Except for the
because a final appealable order was entered in, I believe, January, that was never appealed from. So even if this court sits back and says, you know,
And if they had appealed from that but not appealed from the decree, would you argue that they can't argue the entitlement, they could only argue the amounts?
because of how it was entered under C and B, I would argue that there would be a problem there, Your Honor.
So you're saying if the only concern appellant had in this case was to attorney's fees, both the reasoning, I wasn't unreasonable, that finding was wrong, and the amount, would they have to appeal twice to have us consider both issues?
Yes.
Well,
Well, then,
thank
Well,
goodness academics
I'm sorry,
advise.
and Your Honor, can I clarify that?
yeah, because that's kind of counter to what you're saying.
It is.
Okay.
What I am saying is
It's
that
consistent with what
a
you
judgment
she's
came
saying-
out in January of 2023 for attorney's fees. It was not appealed. This
Well,
court
I
does not have
understand,
a
but I'm saying
jurisdiction
if
over that
the only
judgment.
issue before us is they don't have any problem with the property distribution at all. They have a problem that they were found to be unreasonable, or that the incomes were such that they should have to pay fees. So they have a problem with the determination that fees were available.
Yes.
And they have a problem with the amount. Would they have to appeal both, or could they just wait until the judgment on attorney's fees with the amount is signed, and then appeal and say, I don't like the determination and I don't like the amount? Because that's kind of the rub, and what you said was, yeah.
What I'm trying to say, Your Honor, is if they only appealed from the judgment itself, that they would be able to appeal that. If they timely appealed from the
Right,
judgment.
but they could, and you're saying if they timely appealed from the 78C, you've got $7,000 in attorney's fees.
Correct.
That if they had not filed an appeal on the 78B, where the determination was made, that on the 78C, they could argue both that the determination was wrong, there never should have been fees in this case, but if we're wrong on that, we also are disputing the amount. That's one appeal?
And Your Honor, I have to say, I haven't seen a case that conclusively establishes
Well, no,
that.
that's why we're asking you what you think.
But however, what I'm trying to point out is, even if this court undertook whether or not the finding in the decree that fees were justified, if it looked at that, there still was no appeal of the actual judgment. That judgment is there. It's no longer appealable. If this court comes out and says, yes, the court erred, we still have an attorney's fees judgment, so it's somewhat of a moot point.
Right.
Thank you.
All right, since we drug you 30 seconds over, we'll add 30 seconds to appellant as well. So, please and thank you. Mark?
Thank you.
Hold on just a second. There we go. That's right.
Okay.
There you go. Perfect.
If we're looking at the depositor's intent, which is what the case law requires, is there an intent to gift separate property to the community? With regard to that $125,000 that was taken out, and I don't need to go through the explanation again, but the $125,000 came out of the Navy Federal account, went to various CDs, they matured, went back into the Navy Federal account. I don't believe that there were additional community funds deposited into the Navy Federal account once, between the time period that Dr. Collier's paychecks stopped being deposited into that Navy Federal and was moved over to the Chase.
But, I mean, their argument would be that it lost its separate before it was taken out and withdrawn in the CDs, correct?
That is Mother's argument, yes.
Yeah.
That is correct.
So how do we, assuming I agree with you about the tracing after it came back, but if it was already hopelessly commingled by that point, how do we fix that?
So if there was, if Dr. Collier didn't intend to gift the entire $159,000 that he had in the account at the time that that they got married, and then we're looking at his community funds going in, there should be at least some sort of application of, well, some portion should be his sole and separate property, and some portion would be community property. I don't think I have enough time to argue anything further. So thank you, Your Honors.
I appreciate all the arguments today, especially the arguments about depreciation. Appreciate that, well. Anyway, someone told me that once you get the robe, everyone laughs at your jokes, and you guys just proved that's not true. So, but anyways, we thank you very much for the arguments today. We will take this matter under advisement and issue a written decision in due course.
Thank you.